Hi, everybody. My name is Dave Zapponi. I'm the CEO of ECHO, or otherwise known as the Educational Council of Homeowners. I want to thank you all for participating in today's event, the Rulemaking Process, Investigations, Hearings, and Enforcement. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connection. For today's event, we have a few housekeeping items. These are now presented on the screen. In addition, slides were sent out to registered attendees. Please take a moment to review the housekeeping items. We have many HOA board members today in attendance, which usually means we're going to have a lot of questions. We will do our best to answer them. Please use the Q&A icon, not the chat icon, to ask your questions or make comments. You should use your chat icon to report technical issues and to communicate directly with other participants in the webinar. You will find the navigation icons by hovering over the bar at the bottom of the screen. I will respond in writing to some of the questions in the Q&A feature during the presentation. All other questions will be answered during the Q&A section and at the end of the seminar. Please keep your questions general in nature. Questions about specific situations are better asked of the attorney serving your association or another appropriate industry professional familiar with your specific situation. To help us select the most relevant questions, please use the thumbs up icon found in the Q&A feature. Simply click this upvote icon to select your favorite question. Please find on your screen our disclaimer. None of what is said during this seminar shall be construed as specific legal advice or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision purposes. Thank you. Today we have several sponsors. Please join me in thanking them. Our premier sponsor today is the Kevin Boland Insurance Agency. Our Q&A sponsors are CID Consortium, LLC, and Silver Creek Association Management. Our registration sponsors are Levy Erlinger and Company, CPAs, Ascendant Association, and Property Management. Now we will have a few words from our premier sponsor, which is going to be me at this point, because Kevin is unavailable. He's come down ill. So I want to say a few words about Kevin and his company. First of all, Kevin is a wonderful guy, perfect gentleman, and he works very closely with ECHO. He knows his stuff. If you're interested in getting a quote about insurance, I recommend going to Kevin, or if you just want to talk with him about insurance and risk management. Kevin is also a member of his, he's a member on his HOA board of directors, and so he knows what it's like. He's been in your chair. If you're interested in talking to someone who knows insurance, please give Kevin a call. We will also be giving away a $50 gift certificate card, courtesy of Divergent Consulting at the end of the presentation. You must be here to win that one. Please stay until the end of the webinar. Thank you to all of our sponsors. They make this event possible. Thank you. Now we'll move on to session number 1. Karen St Onge is an experienced HOA attorney with boards of directors on election disputes, rule violations, fiduciary duties, amending government documents, nuisance complaints, and mediations. Prior to joining Adam Sterling, she was an associate with Chapman and Interari LLP for almost 15 years, where, in addition to assisting HOAs, she gained solid litigation experience with construction defects, personal injury claims, complex tort actions, premises liability, toxic torts, and non-judicial foreclosures. Laura Ravazza will join her. She is a certified community association management who has served the industry since 2004. Laura recently joined Silver Creek Association Management as their Director of Marketing and Education. Laura has helped her client communities with varied projects, including major construction work and rewriting of governing documents. She has strong ties with many industry professionals and is a frequent expert speaker at industry events. So we'll now move on to the program. Thank you. Who's starting off today?
We just need Connor to get up to the next slide and we'll take it
there you
away.
go.
All right. Hi, everyone. We're excited to talk to you today about rules. Today, we're going to be talking about the purpose of rules, the duty to enforce rules, drafting rules, adopting rules, actually enforcing the rules, penalties, and thorny situations that we see when managing rules.
Yeah, and so before we really get into it, let's go ahead and look at the next slide here. Let's be very clear about what type of rules we are talking about today. These are operating rules that are adopted by the board of directors. So typically these rules are going to address issues regarding the way that members of the community interact with the common area and with each other. What we're not talking about today are provisions of the CC&Rs that might be restated in some rules and regulations, which is perfectly fine to do as easy reference when there's some really important ones, but we're not talking about those. We're also not talking about maintenance decisions with regard to common areas. That is solely in the discretion of the board. We're not talking about the amount of assessments. We are talking about operating rules that deal with the common area, a schedule of penalties and the discipline procedure in the event that rules are violated, your delinquent assessment collection policy, and your architectural guidelines and review process. So that's what we're going to be talking about today. Now let's, Laura, go ahead and let's start talking about the purpose of rules.
Yeah, so the purpose of the rules are, there's some really three basic things that you're trying to get accomplished when drafting a rule. It's to protect the property value, create a harmonious community, and have a clear level of expectation for owners when interacting with the rules or having to applicably use the rules. We want to make sure that everybody understands what the level of expectation is, what is needed from them, because this is what's going to create the harmonious community in the end, which is the main objective. And of course, everybody wants to protect their property values. So if owners understand the purpose of the rule and then how it's going to protect their property values, and then in end set a clear level of expectation, that creates and eliminates a lot of confusion and hostility when it comes to actually enforcing the rules. On the next slide, we're going to talk about not setting specific rules because of an individual or targeting a particular individual. Sometimes we see board members or homeowners who want rules made that specifically address one issue with one owner. In that situation, it's best to deal with the issue with the owner. The best example that I like to use is, we'll call her Sally. Sally comes tearing in the community. She flies over the speed bumps, doesn't stop at the yield signs or the stop signs, and she drives a super bright purple car that's distracting to other people. So, to eliminate the issue, the rules drafted that you can't have bright colored cars for the community. Well, that's not solving any of the issues. The issues are actually the driving behavior and doesn't have anything to do with the color of the car. So make sure that you're really identifying what the actual issue is and creating a rule that revolves around solving that issue and not just something specific or to target someone else. Next, you don't want your rules to help boost the revenue of the community. Your rules are to help the community to be the best community that it can be. They're not there to boost revenue. So for example, If you charge to do parking permits or pool permits and you charge costs to administer that, that's acceptable. Especially if you work with a management company or if you have a committee and it takes, you know, an hour and a half. Parking permits are a really good example in this situation. Administratively, when you're administering a parking permit, a lot of times there's an application that involves getting license plates, getting copies of leases if there's renters, copies of insurance policies before parking permits actually permitted. So there's administration time and then there's a cost of the permit. So let's say it takes an hour admin time, it's a $50 permit. So your fee to the membership is $150 to get a parking permit. That's acceptable and reasonable given the situation in that particular manner. But you can't turn around and charge $300 because you want to make $150 profit on that parking permit. It needs to be the actual costs. Next, we're going to get into my favorite. Instead of lions, tigers, and bears, we're talking pets, peoples, and parking. Oh my. There's a lot of things that we could talk about for a significant period of time on each one of these matters that impact people. You know, the best way that I can describe this versus going down every single road, every single lane of each one of these issues is I'll pull out the noise issue. I think that that's the easiest one to give an example on. You know, a lot of times when in your architectural policy, I've worked with communities where we do neighbor sign-off awareness on the architectural application process. And that's so when homeowner needs to re-roof their home and they're going to have a porta potty, maybe a storage unit, they're going to have a bunch of cruisers and be loud, dusty, dirty. The neighbors aren't just surprised that the work is going to start and they don't know what's going on, especially now with everybody working from home and, you know, all the various living situations going on. So what we've done is done a neighbor awareness sign off. So the neighbors that are impacted know what's going on, when the work's going to start, when the construction is going to happen, who should contact if there's any issues or concerns or questions. And it eliminates hostility. It creates a harmonious community, and it also sets a clear level of expectation of what is needed from the homeowner who wanting the repairs and the neighbors who are going to be affected by the repairs. So I would identify that in your architectural application process so that they know what they need to do going forward. Next, we're going to talk about the purpose of rules.
All right, yeah, so just to wrap it up, so just when you are drafting your rules, just always remember, or not just drafting, when you are drafting or enforcing rules, just always go back and think about, okay, what is the purpose of this rule? The purpose of this rule is it's going to be to preserve the value of your property and also to promote harmony in the community. If you have a harmonious community, that also translates into higher property values because people are going to want to live there. So just always keep that in mind throughout today's webinar, and then also when you are dealing with rules in general. All right, so next slide. We're going to talk about the association's duty to enforce. So enforcement of rules, go ahead and you can go to the next slide, is not optional. And enforcement happens through the board of directors. It is their duty to enforce the governing documents. Operating rules are part of the association's governing documents. If the board does not enforce a particular rule, an owner does have the ability to file a suit against the association and bring a claim for a breach of those duties. So it is it's a significant thing. Now, what happens if there's a rule that no one enforces? Let's say there's a rule against parking your car in your driveway, but everybody does it. All right, what you should do, let it go. Just let it go. You need to amend those rules, take the rule out. So if the community has changed, if circumstances has changed and no one's following a rule, don't just leave it on the books. Get rid of it and amend the rules properly. All right, so I think now Laura, part of the duty includes duty to investigate. So Laura's going to talk about that.
Yeah, so when we're talking about, the duty to enforce rules, part of that process is doing routine inspections and investigations. If you're a self-managed community, you could do this with the board or committee. If you are with a management company, most of these things should be should be included with your monthly or bi-monthly inspection with your management company. There are certain things that you want to be looking at every time you do an inspection on your routine basis, maybe monthly, bi-monthly, quarterly, whatever works for your community. It can be broken out in 4 different inspections that happen once a week. Or if you're, going with an entire committee or your manager, they can be done all in one inspection. What you're looking for is consistency. You're looking for what are some of the global violations that you're seeing and dealing with. Do you see a lot of trash cans out after the trash cans should be put away, and you seeing a lot of your community members with that same violation? Maybe what I would do, instead of sending violation letters to every single one of those homeowners, I'd put it in my next newsletter or my next town hall meeting or my next board meeting. You can even do on your agendas community inspection discussion and talk about some of the things that you've seen in your inspections and address those and decide, do you need rules? Do you need policies? Is it a general conversation? But what you're doing with routine inspections is you're eliminating selective enforcement. If you're looking at the community as a whole, as violations as a whole on a regular and consistent basis, it eliminates the possibility of someone feeling that they're being targeted. And that's the biggest response that we get, and we'll get into that a little bit more farther down in the presentation. But that is one of the biggest things that we face when dealing with rules, enforcements, and people getting violation letters. And then you break it out into other things. So you're not just looking for violations, you're looking for maintenance issues. You can evaluate your vendor contractors' work. And even proactive management is in your pool pump room. Are your inspection checklists up? Are your pool permits displayed? And are they the right time frames? Just things like that. Do you have all the appropriate tow signs where they need to be? So like, for example, you need to tow a car. Well, if you don't have the appropriate tow signs out, even though your rule says you can tow a car, legally you can't because you don't have the appropriate tow signage. So all of this stuff connects together and can be eliminated with doing routine and regular inspections. Next, we're going to talk about drafting rules.
All right. So when you are getting ready to draft your rules, here is what you're going to be thinking about. Are your rules reasonable? All right. Now we could spend hours talking about what is reasonable. So part of it is just common sense. You don't want rules that are illogical, unfair, too broad, too severe. One question you can ask yourself, does the benefit of the rule to the property and to the community outweigh the burden that it imposes on the community and the property? So that is one thing that you can be keeping in mind. Now your rule needs to be sufficiently detailed. It needs to be enforceable, and it needs to be consistent with the hierarchy, which we will talk about in more detail. So for instance, Laura, why is it important that your rules be very specific? Can't they just say, hey, no bird feeders?
Yeah, I mean, they could easily say no bird feeders, but then if you go to the next slide, this is what the situation is. It's not just a bird feeder, it's a vulture feeder, which is carcasses and pests and big old birds. It's going to cause a massive disruption. And, I like to use the example, again, I go back to the architectural process because I think it's the easiest, most relatable. And then from that, you can take it and apply it to your other rules. So it's like if you have an approved paint color scheme, so you have 6 colored schemes, and each of the schemes has 3 approved colors, and you let those homeowners know, like, you can paint your house, one of these schemes in these 3 colors, but you didn't identify what is the body color supposed to be, what is the trim color supposed to be, what is the front door color supposed to be. You just have the 3 colors. What would stop that owner from going to Kelly Moore and saying, hey, I get to paint my house these 3 colors and I want to do something fun. Can you mix them all together in a bucket? I'm going to paint my whole house that color. Didn't say what color needed to be on what part of the house. It just said it needed to have these 3 colors. Same thing with the vulture feeder. You want to make it as easy and as clear as possible for homeowners to follow the rules. If they're not clear and concise, then they don't know what to follow and they don't know what process to do, which then starts creating all of the emotional responses that tend to not be positive, that we want to be positive experiences. We want homeowners to be like, I called my HOA. That was the easiest thing that I dealt with. They helped me. I know exactly what's needed. I looked at the rules, easy peasy, lemon breezy, I'm ready to go. That's, I mean, we all want to live in a utopia society. We don't. So what's the best way? The next best way to do it is making sure that the expectation is clear. And Karen's going to walk into some examples of clear expectations and rules.
Yeah, so here on the screen is an example of a very poorly written rule. I mean, not only is it this like run on, they're talking about patio furniture, they're talking about smoking, they're talking about litter boxes. Like, how can someone really get their mind around this? It's poorly drafted. Is that when it comes time to like talking about the rule on page 4 of the rules, well, it's going to be more difficult. So here's an example of what your rule should look like. Every individual rule should be numbered so that when you're having a conversation or writing an enforcement letter, you can say, you know, the 6.2 of the rules talks about what you can store on your balconies. So something very simple like that. Take the time to number, letter, something that is going to be easy to reference down the road. All right. So the other aspect is your rules have to ultimately, they have to be enforceable. They have to be enforceable in court also. So Laura, you can talk a little bit more about that.
Yeah, so for a rule to be enforceable, the board has to be given the authority to adopt the rule. And the authority has to be given in the CC&Rs or the law. So a really great example of this is when the election law process changed and everybody needed to update their election rules. I think industry-wide, we saw that, you know, the CC&Rs would say one thing, the bylaws would say another, and then the rules would say another. You know, one of the best ways is your annual meeting should be held in August. Well, your CC&Rs will say April, your bylaws will say June, and your rules will say August. So what month do we have our annual meeting in? When you go to update your rules, you want to make sure that they're updated across the board. So when you updated your election rule, did you update that in your bylaws or your CC&Rs as well and make sure, or did you make sure that your rules are compliant in tandem with your CC&Rs or bylaws when you're switching the rule around? That's a really easy example to use, especially when it comes to election rules, because if the election process isn't clearly identified and isn't clearly followed, you can have issues going down farther about the board not being appointed or elected properly, which can cause a slur of other issues. So if you as a committee wanted to draft the rules, or you wanted your manager to draft the rules and look at the things, I think that's okay. But at the end of the day, I would always make sure that they're blessed by my legal counsel to avoid future liability. And one of the things that I would do is I would call with my attorney, explain the situation, and we need to update our election rules. Our CC&Rs bylaws say this, our election rules say that, and the law says we need to adhere to this. Would it be easier for us to have a half-an-hour phone call to go over what the community's objectives and needs are to meet all of these categories? Is it easier for you, Karen, to do a draft election rules and then I make edits from there with the board and the committee? You know, what's the easiest, most cost-effective option for your community and with what changes you need to make? Not having your attorney involved in the beginning of this, you know, in my experience, you end up paying dividends in the end when a rule wasn't adopted where it matched all the things. And then now you have insurance claims where you're looking at higher premium increases and whatnot. You're looking at potential legal issues. To avoid all of that, being proactive and having the investment up front before you send the rule out for the comment period is to ensure that legal counsel has looked it over and blessed it in whatever way works best for your board and your attorney in that relationship.
Yeah. And you know, you touched a little bit about the importance of making sure that's consistent with your other governing documents. So on the next slide, you'll see that there is a hierarchy as to documents, and rules are at the bottom. So on the top is the law, of course. The Davis-Sterling Act, as I'm sure all of you are aware of, and other laws, that your rules have to be consistent with the law. They have to be consistent with the CC&Rs, articles of incorporation, and bylaws. And those documents have, there's a hierarchy among those documents when there are inconsistencies. It gets really complex, and so anyway, that is an area that needs to be looked at carefully.
Oh, now you're going to get into my favorite, fair housing.
Oh boy. So here's an example of an area of the law that can really trip up associations and cause problems, is that you need to make sure that your rules do not violate any fair housing laws. And that's both federal and state laws. And it's a complex area. The one area that tends to, the one protected category of fair housing, which you can see on the next slide, is familial status. That's the category that trips up associations the most. A lot of language talks about children, and you know, keeping children safe was the idea, right? But that falls under the protected category of familial status. And as you'll see on the next slide, that the Department of Fair Employment and Housing has found that any type of rule that calls out children and distinguishes them so that they don't have the same access to the association is going to be discriminatory. So this is verbatim from an actual letter. And so you had a rule that said children were not allowed to play in the garages, the flower bed, on the road after 8 p.m. So you'd think that's a great rule. Here we are keeping the children safe. That's the whole purpose. The problem is that the DFEH said, no, this rule specifically targets children and is considered a violation of the laws enforced by this department. The rules must be deleted and revised to delete the word children wherever it appears. Then on the next slide, you'll see that this letter went on and it talked about a rule where there was two different family pools. So, and the family pool had different rules. And the department said, no, you cannot have separate pools. All pools should be able to be used by anyone, regardless of their age or family status. Similarly, there was a rule for children's toys and other play equipment, including strollers, must be taken home after use. The department said, no, you cannot have rules that identifies a specific protected group. Rules must be general in nature. Everybody's toys, regardless if it's an adult or a kid, everybody's play equipment needs to be taken home after it's used, which is true. I mean, I had some grown men at 10 p.m. playing with their remote control car in the middle of the intersection the other night. I mean, come on. So grown-ups have their toys too. Anyway.
Lord knows I've got plenty.
All right.
All right, now we're going to talk about adopting rules. You know, there's a lot that goes into adopting the actual rules themselves. We're going to talk about the 28-day notice for adoption, adopting at board meetings, considering member comments, and the proposed rule change. So one of the first things that I like to do when adopting a rule and sending it out for comment period is we know that the rules need to identify what is the text of the proposed change and describe the purpose and the effect of the change. But then also I like to tie it in the cover letter that goes into the homeowner is, how is this rule change going to fit into the mission statement of the community? If you don't have a mission statement for the community, I highly recommend getting together as a community and determining what is your mission as a community, so that when you're adopting rules and you're working through projects, you can tie it back to the mission and create that sense of community. But beyond that, then put the cover letter with the rules and you send it out for the 28-day comment period. Then at the next board meeting, you sit and you go through the member comments and determine if you need to make changes or not make changes and what you're going to do with the rule. My best practice and recommendation is if you sent the rule out for the 28-day comment period and you received a significant amount of feedback, you're going to consider that feedback and make adjustments to the rules. I would then send the rules out again for another 28-day comment period with the changes from the feedback that you received and why you made those changes, because then you're going to get the buy-in from your homeowners much quicker with a clearer understanding. And you don't ever want a rule adoption to be done in like the cover of the night, even though you do the 28-day comment period. You want to be clear and as communicative as possible with the membership and explaining to them why this is happening. So then once you've sent out your rules again, however many times you need to do it, let's say you're around 4 and then you didn't get any feedback, everybody's really happy with the rules, then you can just send out a simple notice that says the rule was adopted based on the rules you received on blah, blah, blah date. That's the final copy. We also store them in our portal or our website, contact management, come to the clubhouse, wherever owners would go or members would go to get copies of the rules. Another thing that you should consider is if you're making, again, I go back to the architectural process, like if you're going to make a change to your architectural policy, I wouldn't just send the policy out. I would send the policy, the application, and whatever other supporting documents that go into the architectural policy. Again, if you have approved paint color schemes or you have approved solar panels that they can use or security doors, keep all that information together. It's a lot easier to follow the rules if you have the information together, and it's a lot better to stand in front of a judge and or a jury and talk about all the ways that you communicated this rule change and how owners enforce it versus saying we sent it out for a 28-day comment period 2 years ago and we haven't talked about it since. You know, once a year could even consider doing a newsletter that just talks about whatever rules, changes, or adoptions that you made in the last year in your newsletter as a yearly recap after an annual meeting or something as well. There's a lot of ways to make sure that owners have access to the information and what's changing in the community.
So
next, we're going to.
No, go ahead. I'm sorry, Laura.
I was saying, I was just going to jump into the next slide of emergency rules. I don't, industry-wide, Karen, you can agree or disagree. I don't feel like emergency rule adoption has been such a large issue. I think it really turned into a large issue when COVID happened.
Yeah.
And we had to start making emergency rules for pools and fitness centers and clubhouses and how board meetings are going to be run and et cetera. Karen, you want to jump into that a little bit more about how that process worked and how and what reasons you'd consider an emergency rule?
Oh, sure. So really the thing to, like I say, it's kind of a rare occurrence, but if there is something that happens, so just remember that you don't have to send it out for that comment period. You still have to adopt the rule at an open board meeting, but that rule is only going to be effective for 180 days. So that gives you that during those 180 days, if you need to, if it's the situation is continuing, like the COVID, it kept going beyond 180 days, you'd have time to adopt rules following the normal procedure. So it just gives you a little bit of a bridge in the event of a situation.
Karen, have you ever seen any other situations where someone would adopt an emergency rule? I mean, I've seen a lot of crazy things happen, but an emergency rule is one of the few things that I haven't seen.
Yeah, I have not, other than what happened a few years ago. Yeah, but yeah, maybe there's.
So maybe we're all kind of like industry wide on the same page. I mean, again, it have to be a pretty extreme reason for an emergency rule.
Yeah. All right, so now we are going to move on. We're going to talk about enforcing these rules. And, the thing is when it comes to enforcing rules, I'm going to tie it back to remembering what the purpose of these rules are. And it's to promote a good, harmonious living environment, promote civility, and you want the enforcement ultimately to end in people complying with rules and not punishing rules. This is not, the enforcement of these rules is not to call out people, humiliate them, and make them feel bad about what they did. People mess up. People forget their garbage cans. They go out of town and they totally forget to bring the garbage cans in. So yeah, people make mistakes. So anyway, so just keep that in mind when you are dealing with enforcement. All right, so part of that duty that we talked about before is to investigate. Now, let's see, there it is. So, when there's a violation that is brought to your attention, before you send out that notice of violation, do a little investigation. Make sure that this particular owner was not given a waiver due to a reasonable accommodation that was needed for a disability. So for instance, if their driveway extends, the concrete extends into the landscaping, and their next door neighbor brings this to the board's attention and you had never noticed this, and you realize, you look back in their file and you realize that, well, that was needed for someone who had a wheelchair. They needed that additional area. So take a look at the file and slow down and see if maybe the standards had changed since they had made that particular change. So just take a moment, take a breath, investigate. There are going to be defenses to rule violations. All right. And then, there we go. Grandfathering in. And next slide. Yeah, so there we go. Now we're going to talk about what's the first step after you do your investigation.
I always, like you said earlier, everybody's human, everybody makes mistakes. So I like to lead with a solution-based and as friendly as I can be to discuss the violation. It's awkward for the owner, it's awkward for the board, and sometimes it's awkward for the manager too. So I want to be very aware of that. Sometimes let's try to start a little bit friendlier. It could be a phone call, or you could work on drafting like a first courtesy notice instead of jumping right into a violation notice. I sometimes see that people are a lot more open to a conversation if the top of the notice says courtesy letter before jumping into a violation letter. And explaining to them, this is a problem, this is how it affects the neighbors, this is what it's violating, this is what we're looking for resolution. What are your thoughts? What are your specific situation? Can we work together to resolve this issue? Is it solely just on the owner, needing to clean up after their dog? I'm all about helping someone, but I don't know if I'll go out there and help them pick up their dog waste. I have to draw a line somewhere. But maybe we have the conversation. Maybe I can share some tools and tricks that we use and make sure we clean up regularly after our pets. But just having that open dialogue and that open conversation, because when a member buys into a community and they buy into the home, they're planning on being there for the long term. So you don't want a hostile interaction to be the first interaction where they're defensive, you're defensive. You want to create and build that relationship that you're going to be managing and working with for an unspecified period of time. A lot of our owners have lived at communities for 30 to 50, 60, 70 years. You want to make sure that you are building that relationship up for success, because not only is it going to be between the board and that member, but that member is going to have friends in the community as well. So it's going to create that sense of community, and they're going to be like, oh yeah, I talked to Sarah, the board member, and she gave me this great grabber thing, so I don't have to bend over to pick up the dog waste, because it was killing my back to bend over and do it. Here's the Amazon. Do you want one too? And then it's creating that relationship and the conversations and helping each other out and looking out for each other, going back to the harmonious community. It starts with the baby steps and being consistent about the baby steps to get to that bigger picture. Next, this is the funny little slide that Karen found. A message from the homeowner association. Majesty, I don't want anybody to feel that. I watch a lot of YouTube videos and stuff on people that get violation letters from their HOA and their reactions. And, you know, there's a lot of funny stuff out there, and it's funny to laugh at in the moment. But at the end of the day, that's not what any of us want. I don't think that's what any of us are desiring. I think we're looking, you know, to solve the resolution. On the next slide, ironically, the owner just removed the basketball hoop, so we don't have to siege at dawn. Fantastic. We love that. Maybe we don't need to do it in such aggressive way. Maybe the owner would just take the basketball standard down if they knew why it needed to be down.
Or
And then right. And
next,
then
yeah,
on the next slide. You know, I think one of the things too is the perception of the person receiving. So not only the person receiving the violation notice, but also the person who has to receive the response to the violation notice. Neither one of you want to be going back and forth at each other. So again, yeah, maybe we eliminate death threats for a little while. All right.
All
And the
right.
next slide, Karen, you want to get a little bit specifics on the letters?
Yeah, you got to be specific about the specificity of your letter. So here's an example of a letter that is not going to help anything. So the first box, dear owner, it was noted that you are parking your car in violation of the governing documents. Well, that's really vague. How are they supposed to know what exactly they're doing wrong, what car, when? So example of, you want to use a lot of specifics. The next box, dear owner, it's been reported. Again, you're not saying that they did something. All you need to just, it's been reported to you. It hasn't been proven that since April, you have been parking your red Corvette, license plate too cool for you, in the guest parking space next to your unit, which is a violation of parking rule number 10, section 6.8 of the CC&Rs. See enclosures, maybe there's a photograph of the car. I recommend referencing in the section of the CC&Rs that actually gives the board the authority to adopt parking rules, so that they see that, oh yes, it's a parking rule and we have the authority to impose it. So even if the CC&Rs just say the board has that authority, but not the actual specific rule. So I think that's a good one to add in that letter. And go ahead, that first letter, go ahead and include the evidence. There's no reason to hide the ball. If you have a picture of the, go ahead and move to the next slide. If you have a picture of the car, just include it with the courtesy letter. There's no reason to hold it back, All right, next, we're going to, Laura, you can talk a little bit about if this courtesy letter doesn't work and they're still parking their red Corvette in the guest parking. The next step, which is having them come to a hearing with the board.
Yeah, but Karen, my first question to you is, if it is a red Corvette, is there a way to send them the song Little Red Corvette?
Exactly. You can include it as a video link. If you send them an email, embed the YouTube link. Get creative.
You want your hearing notices to be extremely clear. The point of a hearing is to open the door of communication and allow the board and the member to hear each other and work for resolution in the violation. It can be, obviously, it's very intimidating to receive a hearing notice. It puts all the hairs on the back of your neck stand up. I like to include verbiage in my hearing notice that's, talks about, we want to sit down and spend some time together in executive session to talk about exactly what the issue is. And I would indicate what the issue is: your red Corvette parking, blah, blah, blah. The hearing is going to be, and then separate it. So have 3 bullet points. So the hearing date is this date. The hearing time is this time. The hearing location is here, or if it's on Zoom, here's all the info for Zoom. Here's a way to log in, and then here's the information to call in case you can't log in. If Zoom, sometimes what I'll do is put a little caveat underneath the Zoom. If Zoom doesn't work for you, or you have need a different platform to have your hearing, please contact management, board, violation committee. by such and such date so we can accommodate your needs. Because sometimes Zoom, maybe, you know, if there's a lot of physical things they need to bring to the hearing to show you, Zoom might not be the best platform to do that hearing in. And you may need to, you know, find a common meeting place during the day to do that specific hearing so that they can bring whatever it is that they need to bring with them for the hearing. So you just want to describe the hearing date and the location, what their rights are, that they can attend the meeting in person or on Zoom, or they can attend by responding in writing. You know, maybe they're on vacation, maybe they're going through a personal situation and they just don't have the wherewithal to actually physically attend the hearing. They're more than welcome to submit their response in writing for the board to consider as well during that hearing. I would indicate what day that you need to get their response by in writing so that it can be considered for the hearing. You know, I always like to try to give a minimum of 2 to 3 days before the hearing so that the board has enough time to review their response and to make sure there's not any additional questions that need to be gathered or anything before the hearing. And then the board should honor, sorry, Connor, sorry, one more thing, and whatever the possible discipline and fines are. So I always like to say, you know, you have the option to be facing fines imposed by the community, a reimbursement assessment, whatever it is that the actual consequences, you want that indicated in the notice that they're receiving so they know exactly what it is that they're walking into and what's going to be expected of them. Now, let's say the owner can't attend the hearing and needs to reschedule. The board should really consider rescheduling the request, especially if it's the first hearing and it's the first time they requested a reschedule. There's a lot going on right now, and sometimes, you know, 10-day notice for the hearing notice isn't enough time, and there's, you know, the calendar things going on with the owner or whatever else. So I'd always try to accommodate a rescheduling, but you don't have to jump into a rescheduling game. You know, let's say you called them to 3 separate hearings, you rescheduled 3 separate times and they still can't make it. You know, that you've definitely gone above and beyond. And they also have the option to submit their response in writing, and they don't have to physically be there either. So just use your best judgment. When in doubt, talk to your subject matter expert about rescheduling. Just eliminate any gray area. But I would at least reschedule 1 to 2 times, depending on the situation. Health and safety or life and safety, I obviously wouldn't reschedule, but anything beyond that. So next we're going to talk about the actual letter itself. You know, we kind of talked about this, just talked about this a little bit ago. Again, I would just want to reiterate that they can attend in writing. If they're going to attend in writing, I would either consider maybe having a conversation with them real quick, a phone call or something, just saying what it is, you know, that they should consider putting in their writing, or if they have any questions, or once you get it, review it before you send it to the board or to the committee or everybody else on the board, just to make sure that you don't have any other questions. So it's a clear summarization of what the owner is going through. A lot of times this will be their first time going through a situation like this, so they don't know what they should be putting in there and they don't know what's going to be expected of them. I'm not saying give them advice on what should be put in the letter or anything, but you can give them some tips. You know, what are the top 3 things you need to know? That yes, it's happened. What are you going to do to resolve it? You know, whatever it is that your level of expectation is need for resolution to that particular violation.
Yeah, I think it's important to remember it's all about, you know, the purpose of the hearing is to resolve it, right? It's just to be able to have a meeting of the minds, and it's not about, ooh, we get to impose a fine, woohoo! Like, no, it's really about let's do this so that we resolve the problem and everyone lives happily ever after, right? So you're going to have that hearing in executive session. Even if the member asks, oh no, I want to have this an open session. I want all my neighbors to be there because I want to be able to, you know, tell them how unfair this rule is, and they're going to hear about it. They're going to hear how it's not fair. That's not what this is about. That's not the correct forum. It's going to be an executive session. This is about resolving the problem. And, you know, if it's just the owner and the board, without an audience, there's going to be a lot better chance that people are going to be reasonable, temperatures are going to stay down, things are going to get resolved. It's also important to avoid any possible claims for defamation. So that's another reason why you want to have it in executive session, so that so that all that information, the alleged violation and the discussion of that alleged violation stays between the board and the potentially offending owner, the alleged offending owner. Yeah.
So, I mean, I know that technically you have an owner has a right to have their hearing in open session. If that's the case, and if they really do want to go that route, as a professional manager, I would never entertain that dynamic without my legal counsel involved. There's a lot of things that could go astray. It's a very unique situation. It's very sensitive, and it can at times entail a lot of emotions. I would have a pre-meeting with my legal counsel. Like, I wouldn't even as a manager do that. I would engage my legal counsel to help in that situation and set up what are the level of expectation, how it's going to be handled, what's expected of the board, you know, and so forth. But I wouldn't just go to a open session hearing without some backup.
All right.
If the owner doesn't show, you 100% can still impose penalties because they didn't appear. They don't have to be present to be fined. You just need to make sure that they get the notice properly. You do have a duty to review the evidence and make your decision based on the evidence. If there's pictures, statements, videos, police reports, whatever the case may be, but they don't have to be there for the actual hearing itself. You know, we all know what the most used defense is, as we talked about this earlier, is look at all the other violations. Why are you picking on me? And this goes back to our previous slide of doing routine inspections. If you're doing routine and consistent inspections, it eliminates a lot of this, but it doesn't take it all the way. And we all know that those issues still happen. You know, one of the best things that you can do in this kind of situation is making sure that you're actually enforcing the rules globally, but then going a step farther and making sure that in your open session minutes, when you're summarizing what happened in the executive session, and just instead of just saying an owner received a fine for $50 for parking, you can put owner received a $50 fine for not having proper registration displayed on their vehicle for more than 90 days while parking in the property. So that way, when other people are looking at the minutes or new owners come in, oh yeah, they actually do pay attention to make sure that cars are properly registered and not dilapidated, just being stored in the community and people living in them, etc. The second most used phrase is, I didn't do it, wrong guy, it was Susie, it was Joe over there, we're pointing every direction but myself. In that situation, you just need to make sure that you have as much information together as possible regarding the violation. Do you need to talk to other homeowners? Do you need to talk to maybe the landscapers? They might have information, they're there weekly. What the specific situation. So I like to use, I had a hostile homeowner who loved to go and berate the landscapers, but then say it wasn't him and run back to his house. So it took a little bit while to narrow it down and get together evidence that it was him. But like, once the neighbors in the community heard that their landscapers who they really liked are being attacked, it's amazing how much Ring doorbell footage I receive, cell phone videos I receive. I got a letter from the owner of the landscaper experiencing the situation, summarizing the situation, what his crew's gone through. In the one time, the pool guy ironically was there at the same time and was like, hey, what's going on? So he wrote down what he saw and witnessed and description of the person. So when the guy is like, I didn't do it, it's like, oh, you know, I understand you think you didn't do it, but here's some videos, here's some pictures, here's some statements. where do we want to go from here? Can we stop
Mhm.
yelling at the landscapers?
Yeah, yeah. So if the board has a good faith belief that the owner did actually commit the violation based on all that stuff that came in, the board can still move forward. You just need to just document it. After the hearing, it's really important to deliberate, and you're looking at the facts. You got to keep your emotions out of it. Because members of the board, this is part of your community. You have an emotional investment. This is part of your day-to-day life. It's really easy to have, start resentments towards a particular owner and be, I want to punish him. I want to just, put him in his place or put her in her place. You've got to stick to the facts. Also remember that at the end of the day, if the person does not pay the fines, doesn't change their behavior, and you really want to enforce, you're going to have to go to court. And you're going to have to explain to the judge everything that you did. So just think about, what it's going to be like. What are you going to tell that judge, why you imposed the fine, why you took away their right to use the gym, if that is, as an example. So just remember that you're going to have to explain it, and you're going to want to have very good facts, not an emotional response. And anyway, you can, after the hearing, the board votes and decides if they are going to dismiss the accused or impose a penalty. All right. Now, what you do after you get done with your discussion in executive session, next slide, is you are going to record everything in your executive session minutes, and you're going to want those to be pretty detailed. Now, this is not going to be a transcript of the hearing, but you are going to want to say what evidence was presented by both sides, what the arguments were by both sides, and then state what the decision is. This is pretty helpful, especially if, in a year or so, this issue is still around, and directors have forgotten, they can't recall, or if they move and they're no longer around. So it's going to be important to have that sufficiently detailed. Now, when it comes to your open meeting minutes, those are going to be more succinct. You're not going to identify the owner who was penalized, if that is the decision, but it is important to identify what the fine was, or the penalty, and you're going to want to identify what the violation was. And one of the reasons is, as we mentioned earlier, is that this is going to be evidence in case someone down the road claims that they're getting picked on, is that you can go, no, look back at the meeting minutes from the past 2 years, and you'll see that we've been fining people for parking cars in the guest parking spots, and they all have been getting fines and, etc. So that those open meeting minutes are going to be your best evidence to show that you are fulfilling your duty to the association to enforce the rules equitably.
And it's
All right.
also great for new board members too, that they can go through and look at the minutes to see what reasonable accommodations have been made, what kind of things that you've been fining for, so they know what the level of expectation is for them as board members too.
All right, so then after you make your decision, make sure that you give notice of that decision to the homeowner involved, either by mail or personal delivery within 14 days, unless the governing documents have a shorter notice period. All right, so make sure that they get notice of it. And you're going to want to keep some type of a receipt of that notice, because ultimately, again, if you end up in court, a judge is going to ask, well, hey, did you give notice of the fine and penalty? And you go, sure, I put it in the mail. And then be like, okay, well, can you prove that you put it in the mail? So take a copy, or I don't know, document. your file to show that you did actually provide service, pardon me, of the notice. All right, so let's talk a little bit about the types of penalties and fines. Now, this, of course, is an exaggeration. No, penalties and fines are not there to punish and torture people. Again, it's really just to motivate. You want to motivate people to do what they need to do to make a harmonious living environment. All right, so fines. This is an example of a fine schedule that is not going to be effective, and it's just not going to do what you need it to do. So why is that? Well, so let's say that the first offense, which under this fine schedule is just a warning. What if the first offense was that someone pulled the fire alarm and, it caused incredible havoc? Everyone, had to leave their building. The fire department came out. When the fire department found out that it was a false alarm, they sent you a bill, and the association had to pay that. You need to have a fine schedule that is flexible enough, that gives the board discretion to impose a larger penalty and seek reimbursement, even if it's a first offense. Nobody should be pulling false alarms. All right, so here's another example of you want to be sensitive about the amount of money that you are imposing. Think about the economic situation of your community. If you have a lower income population, think about be sensitive to the amount of money that you are imposing on them. Conversely, if you have a luxury high rise, a $25 fine, is not going to motivate people to stop parking in the guest parking spot. Not when parking spots go for hundreds of dollars a month. It needs to motivate people to comply. All right, so
I actually had that happen where it was a parking and the owner paid the fines for the entire year up front for his parking space and said, you can save the postage. I'll just pay all the fines. Here you go.
There you go.
I was like, okay, that's not technically how that's supposed to work. What are we doing here?
Yeah.
Some of the other recourses you have available is suspending privileges. For example, you could suspend privileges to your gym, your tennis court, your bocce court, even to your swimming pool. About 2 weeks ago, we had an incident at a community that we manage, a large-scale community, and a homeowner physically assaulted one of the on-site employees. Well, obviously, if we would have had the first fine policy that Karen just talked about, there'd have been very little that we can do. But stepping into more clear and aggressive fine policy for serious situations like that, if you go to the next slide, Connor, would have allowed for immediate suspension of access to common area things like the pool, the gym, the clubhouse itself, softball courts, whatever the case may be. And then, immediate presence in front of the board, a safety violation, as you can see in this policy, is a warning or a fine up to $1,000. So you're skipping 1 through 3 because you're going right to the safety violation. So think about the things that go on at your community and what's egregious enough to set certain fine limits for. I've seen condo communities set fines for not following their plumbing policy. They have recirculating piping system, and it needs to be shut down a certain way and charged back up a certain way. But a homeowner just calls their plumber. They don't know anything about recirculating systems, shut the building water off, make the repairs, turn it back on. Well, now the whole system is a mess. The whole building doesn't have water, and you need to get plumbers out and everything else. So that specific community had $1,000 fine for violating a plumbing policy, plus all the cost and time and materials costs for the plumber, management, etc., to resolve the issue. So that way owners knew, if I don't follow this plumbing policy, here are all the things that I'm going to have to face. And even owners buying into the community knew, like, oh, I need to be aware. Who do most of the homeowners use for plumbers? This is something you can put in the newsletter. Did you know that you need to do X, Y, and Z for the plumbing policy? So you're re-hitting it and you're telling them numerous times, different ways, in identifying clearly what the consequences are. And these consequences would be transposed into the hearing letter that we talked about earlier. Karen, you want to talk about when people ignore penalties and rules?
Wait a minute, that happens? I
Never.
thought after you impose a penalty, people just change their behavior or pay the fine and everything is perfect. No? All
Yeah,
right.
my wand is still in the wand shop, so no, it's not working yet. Sorry.
Got to get that fixed. All right, so I'm IDR, ADR, if you guys are familiar, I'm sure. Okay, internal dispute resolution. So this is an option that is available to try to resolve issues. This involves, you can have the option of having your lawyer there. They can have their lawyer. Everybody pays for their own lawyers, but sometimes that will get things resolved. Then if that doesn't work and there's, you can try a ADR, alternative dispute resolution, which is mediation or arbitration. This is going to, it's more expensive. You need to hire a mediator, a third party neutral, unless you can find someone to volunteer, which you can sometimes. You can get people, mediators to volunteer a couple hours, depending. Try to resolve it that way. And then of course you can always go to court. Small claims, for some situations, better to go to superior court if it's a really significant issue where I would recommend, you want to not have a small claims court judge making a really significant issue, ruling on an issue that's going to really affect a community, just because they don't have a lot of time to spend on it. So anyway, so those are your options, but hopefully if you have done everything that we talked about, you won't get there, but it does happen, right? I'm sure you,
Yeah, small claims is my specialty. And it's hard going to small claims because you can't bring your legal counsel. So it's up to you as the board representative to go yourself or work with your management professional to talk about whatever the situation is. And as Karen just said, the small claims judge does not specialize in HOA law. So a lot of times you find yourself having to educate the judge a little bit and educate the mediator that you'll meet with before you even talk to the judge about the situation. So if you're going to end up down the road of small claims, I always just go into any hearing or any violation, assuming I'm going to small claims, and document, communicate. So unfortunately, if it does get to that point, a lot of stress is off of my back or my board members' back because they're going in prepared knowing that they did what they could. Next, we get into some thorny issues. I had a really sensitive issue go on for both parties involved in a condo community. Susan, the neighbor, was experiencing a lot of pest issues, all kinds of different pests, bugs coming into her home from her neighbors, their townhomes shared from her neighbor's unit. And it had been going on, it was a little bit for like a week. And then it got significantly more. And then I think it was like 3 weeks into the process of me trying to work with the other owner to see what's going on and make contact. 3 weeks into it, Susan got up in the middle of the night because she heard something, turned a light on, and her entire kitchen was just covered in bugs. And it, really triggered her, a very emotional situation for her. She was very, very upset. And I still couldn't get a hold of the owner next door. So then I ironically had a site inspection the next day after this inspection, after she noticed this in her kitchen. So I went over there and tried to knock on the door and see if I could see what's going on. When I went over there, I'm sure you can tell where this is going. I saw a lot of bugs in the window. I obviously, been doing this for a significant period of time, and I knew something was significantly wrong. I immediately notified the police, asked for a welfare check. I stood there and waited until the police came for the welfare check. I tried seeing if there was emergency contacts for this person because it had been 3 weeks and I hadn't got a hold of them. Long story short, at the end of the day, the owner passed away in their home, and that's why they were having bug issues. So Susan next door is screaming through the wall at her neighbor, who she thinks is just a mess, a slob, all these other things. when really they both were obviously very sensitive situations. So keep that in mind when you're dealing with violations. We really don't know what the whole story is. And as Karen had mentioned earlier, we want to go into it with the intention of helping resolve the issue and understanding where the member's coming from, not from an automatic blame. It's your fault, you're wrong. Let's look at it holistically. Next, we're going to talk into a little bit about neighbor disputes. Those are also obviously very emotional charged. You know, I had a neighbor who in a single family home community who did family Sunday dinners at their house every night, big, huge backyards. The neighbor next door would get so mad at the noise that she would spray her hose over the fence and destroy the food, what the people were wearing, ruin the whole thing. So I finally, you know, after the second time that it happened, the neighbor, I didn't know about it the first time. They called the police and tried to go that route. Second time, told me what happened, called the owner and, you know, and just talked to her and said, hey, you know, are they being super loud? Do you have video of the issue, like the noise, anything that you can share? And she immediately started crying. And she said the reason why she was doing it is because she doesn't have any family and she's by herself. So when she hears them, it triggers her emotions and she just emotionally responds. And, you know, we talked about it. She understood it wasn't appropriate and, you know, was able to work through it. And it would, you know, that kind of stuff doesn't happen all the time. Those are the unicorn stories that we hear about. But if we use those unicorn stories as our rule of thumb, sometimes we can still get resolution, even in the hairiest of hairy issues where we're not going to get that unicorn ending, but we can still use those skills that we learned to help resolve some of the issues. When it comes to illegal activity, it's a lot stronger of an issue. You know, a community can be deemed a nuisance as a whole by the city if they receive too many calls from the police department or dilapidated property. You know, there's nothing worse than a community being deemed a nuisance. You know, you really want to work together to make sure that the rules for the community are being followed. And when you have to deal with illegal activity, having that open line of communication with the police department and even the city. You know, there's a lot of times where I'll go introduce myself to the city manager or the people, the city clerks work in the office and give them my business card and just say, I represent this community. It's 800 homes in the city of, you know, the North Pole. So if you ever need anything, if we could be a resource, if you have questions, you know, we want to be there. But also if you're having issues in our community, feel free to contact me. You can do that as a board member too. And you're creating that harmoniousness, not just even in your community, but you're taking it a step farther into your city.
That's awesome.
Yeah. So in summary.
All right, quickly, we're going to summarize. All right, your rules need to be written. You want to make sure those rules, the whole purpose of them is to promote harmony and preserve property values. It is not to annoy people, people that you don't, no, I'm sorry, you don't want to punish people that annoy you. Yeah, yes, or annoy other people with all your rules. It is not there to make life harder for people, it's to make life better. The board has a duty to enforce them. If you're not going to enforce a rule, just amend your rules to strike it out. Due process, when you need to enforce those rules, make sure that the person has notice of the hearing, that you have evidenced facts to back up the decision, the violation, that they're given an opportunity to defend themselves either personally or in a letter, and that no lawyers are actually involved in that hearing. It's really just about the owners and the board working things out. Your notice of decision needs to be sent out and served. Keep record of that, and then make sure that you have a good penalty schedule that has a flexible fine schedule, fine structure that gives the board discretion, a little bit of discretion to a particular situation. It provides for daily fines for continuing offenses, and include, if there are common areas and common facilities, a suspension of privileges, which can also may be appropriate, you know.
So just remember all of that for every violation. No big deal. It's fine.
Yes, right. It's just a short little list. It's just it's super easy. All right. And so we're going to leave you with a quote. Laura, go
Civility,
ahead.
civility, it is said, means obeying the unenforceable, which I feel like is what we all deal with. So how do we work through that and get through that better? I know Karen and I really appreciate you guys listening to us and all the feedback. We know we could have gone a lot of ways on this, and it could be its own entire series, and we tried to do our best to cover as much as we could today. So thank you very much.
Okay. Well, thank you both very much as well. We appreciate it. I'm sure the people in the audience appreciate it, and we will be sending out the slides shortly. Now, we're going to jump into the Q&A session. We have about 10 or 15 minutes that we can go. We're going to probably about 2:25 here, and then go out to do our drawing and close out the meeting. So let's go ahead and move to the Q&A portion. I'm going to ask the attendees to vote for your favorite question, and you can do that by going to the Q&A feature, and at the very bottom left of the screen you'll see the thumbs up. So you highlight the question that you like, and you press the thumbs up, and that'll be a vote for that question, and that should help us. I've tried answering a bunch of questions during the sessions. I think I got most of those. If I didn't answer to your satisfaction, you can place those in the Q&A as well. So let's go ahead and do the voting. I'll give you a couple seconds for that, and then we'll go ahead and start answering the questions. And for Karen and Laura, you might just take a look at some of those questions at the top. And there's a little feature that says most upvotes in the upper right corner under dismissed. And you go ahead and click on the caret down, and you'll see that. And you can go to the most upvotes, and we'll start at the very top of that list.
All right, so Karen, I'll read, and then we'll get started together.
All right, let's see.
What expectation of communication should the homeowner receive when they report a violation to the management company and the violation continues, giving the appearance that nothing is being done for an extended period of time, i.e. months? Ooh, I'm going to take this one.
Yeah.
So what I like to do in a situation like that is create a log. If you as the complaint, or I'd say it's like noise, dog barking, create a log for, a week or two that shows, even if you just do it on your phone and like a draft email that says, Tuesday the 12th at 1:20, dog bark for 2.5 hours. Wednesday, same thing, send that over to management. Sometimes, what a lot of times is we're making action, but the owner isn't doing anything, so it doesn't feel like any action's being taken place. But the more information that we receive, the better the better it is for us in the long run, and ultimately helps us resolve the issue. So when you feel like it's going on for months and not being resolved, maybe you just contact either the board member, the manager, whoever it is that you're reporting the issues to, tell them how you're feeling and see if there's anything else you could do to aid in the situation. But I'm a big fan of a log. It's clear, concise, and I can use it in front of a judge and jury if I need to. All right, Karen, the next one. If the board has mailed out rules for the review period, are they required to mail the rules again, even if there were changes made?
Well, I think you talked about that. Wait, so if there were changes made, well, I think if you're going to roll back some changes where it's just you go back to the status quo, then you wouldn't need to send it out again, right? But if there's significant changes after those comment periods, then yeah, send it out again. Let's see. Yeah. I think I've answered the question there. Yeah. All right. Let's see.
So the next one's kind of the same one. If the board mailed out the rules for the review, oh wait, no, here it is. Sorry, I just read the same question. If the adopted rules were not sent within the 15 days, will the valid years later, because they've been handed to new purchaser, nobody complained? I don't quite understand that question. I'm going to jump on to the next one. Violation hearing. What if the owner is aggressive and threatens to send attorney to meeting? Is owner allowed to bring a lawyer to the violation hearing? Karen, you and I talked about this a lot.
Well, I just don't think that it's not going to resolve anything. That really, if an owner wants to get their lawyer involved, then go to IDR. That's really the place for your lawyer to be. So,
Yeah,
you
an
want to,
executive session hearing with the board isn't the right platform.
yeah. So it's just, it's really, again, it's just about what are you going to do to resolve this issue? Yeah. All right.
All right. This one says, this is kind of community specific. I don't really feel like we can answer that one. It says they have a clause in their CC&R saying the board can decide not to enforce an owner reported violation of the rule. Is that clause itself enforceable or legal? I mean, you would have to look at like the CC&Rs as a whole and
Yeah.
all of that, right? Yeah.
All right. If
Um,
previous boards failed to enforce rules such that there is a mix like window trim colors, can the existing board enforce a rule on new activity? All trims must be black. Yeah, so the board does have the ability to change those architectural guidelines. That's part of their role. So if having black trim is much more fashionable and is all the rage, then they can change those.
I see that a lot of like window retrofits, like everybody likes to identify like what color the retrofits need to be. I see that a lot there. All right, Vicky is asking a pretty specific question about smoking ordinances. Her city has a smoking ordinance and the manager board are enforcing it. Again, that's really specific. We'd have to look at that ordinance and what your rules are and everything else. I will say that I know in the Bay Area, there's a couple different cities that have smoking ordinances. If you look the smoking ordinances up, it clearly identifies what are the steps if they're not being adhered to or followed. So I would suggest looking there, contacting the city or calling your manager or board member and asking what's going on.
Yeah, but I mean, as far as going to the city, nothing's going to stop you from going to the city. Yeah, you can do that.
Especially if they're doing multi-unit dwelling bans, like I know Concord and I think Dublin does. Yeah, they may have it pretty spelled out. All right, Karen, can you force someone to undo an architectural change that is a violation?
Oh boy, I think that's a little too fact specific. So
yeah.
Should all board members get to weigh in before property management sends violation? Well, yeah, I mean, that's something, I mean, I think that don't you basically, Laura, kind of set those standards at the beginning of your relationship? You decide how much discretion that the manager has.
Yeah, and like we always do our first inspection together as a group with the board and management to make sure that we understand what everybody's level of expectation is. I always say it's better for the board to have a clear expectation of management of what they want with violations, but I don't know if I would necessarily go through trying to approve every single violation. It slows down the process significantly. And then all the timelines for hearing notices and all that kind of stuff, it slows all that down. And then B, there could be the perception that, again, the targeting, if management's doing it or your committee is doing it as a whole, it removes the idea of selective enforcement.
All right, can a newsletter announcement of the rule change suffice? So the rule change needs to be noticed through what's called general notice, and the statute defines general notice, and a newsletter that is sent out to everybody on a regular basis is one of the forms of general notice that is acceptable. The type of general notice that is going to be used should be included in your annual policy statement. The only time that the newsletter would not be suffice is if a particular owner has said, I want what's called individual notice. Again, that's a statutory term that's specifically defined in the Davis-Sterling Act of all association notices. Like, no, I do not want my notices to come from a newsletter. I don't want them posted on the community board. I want them sent to me either, like email or regular mail, however, depending on what type of individual notice the association is using. By the way, all of that changes next year. So what the definition of individual notice is changing next year to be whatever the specific owner selects, and that can be email or mail or both. So yeah, again, it kind of depends.
Okay,
So,
one more question, last question.
how to
This is my favorite. I've had to do this all the time. So if you need to redo all of your rules,
What's the
the one thing I
question?
do, sorry, is how do you, so I got so excited to answer. It says how to reset the community with operating rules when lack of enforcement has been going on for some time. So what I like to do is immediately set up a committee that's going to go through, make all the changes, get it blessed by council, and then set up a town hall. Ask your contracted vendors, your management company, your insurance professional, your pool people, your landscapers to give out raffle prizes to get people there. All of us will donate raffle prizes because we love stuff like that. And then just sit down and have an open conversation with your membership. Say, hey, we have these super outdated rules. We're not enforcing them. People aren't following them. They're not really clear. We're going to do X, Y, and Z, or we have X, Y, and Z, and we're going to send this out to your comment period. But make it a community thing. Explain to them, why you're doing it. And if you don't have a mission statement, it's a great time to set up your mission statement too.
Well, okay, so I think we're finished for the day. We have a last couple of announcements. Unfortunately, we have 77 questions unanswered. Sorry, I think we've answered probably close to 50 or 60 questions today, either in person or in the chat or the Q&A feature. So I do want to say again, thank you very much to our speakers today, and I will. Just give me a second here, pull up my announcements. So to Laura and Karen, thank you so much for your day and giving us your expertise on this particular topic. I want to thank you for being a member. That is everyone who participates for being a member of ECHO. But if you're not a member of ECHO, we would really appreciate it if you consider joining. This year, ECHO has planned more than 60 online events. In addition, we offer a vast array of other resources for HOA boards and homeowners, including personalized guidance on challenging issues that they face and series of educational programs. You can join ECHO by going to our website at www.echo-ca.org and clicking on the membership tab. For those of you who are interested in meeting in person, our next in-person event is next week in Capitola, which is in Santa Cruz County. The Central Coast Resource Panel will meet on August 17th from 11:30 to 1. The topic is conserving water and saving money with a landscape water management plan. We we invite you to participate if you're a board member or former board member to participate in our ECHO HOA Board Members Club. This exclusive group meets every second Tuesday of the month from 5:30 to 7 p.m. and features a unique opportunity to learn from your peers. Please consider joining the club. We currently have about 230 members sharing information and knowledge every month. If you are interested, please contact Patty Curzette at echo-ca.org, or there's a link in the packet that's going to be coming out to you. You can just click on that. Well, this has been a lot of fun today and very, very interesting. I want to thank Karen and Laura for your wonderful presentation and personal insight. Once again, thank you to all of our sponsors who have made this broadcast possible for everyone to view. And of course, thanks to you, the attendees, for participating today in today's webinar. ECHO appreciates your investment in education to build better HOA communities.